welcome to the HPMA Yorkshire and Humber branch webinar, which this afternoon is on handling industrial action, the essentials. So we're hoping this is potentially a hot topic, or certainly one we all, myself included, perhaps could do with a bit of a refresh on, given some of the climate that we're now in. We've got Andrew Davison here, who's going to present to us from Hempsons, and we're being supported on the webinar by Heather Bellis, also from Hempsons, who's done all of the organisation. So thank you both very much. I'm Jenny Allen. I'm Director of Workforce for Leeds Community Healthcare Trust and the Leeds GP Confederation, and I job share that role and also the role of Vice President for the Yorkshire and Humber HPMA branch. So it's great to see so many people join us. I hope you'll find the session useful. Just to note, it is being recorded, so I hope everyone is okay with that. And of course, we can edit post the discussion and so on if we need to. So without further ado, Andrew, I'm going to hand over to you and leave everybody in your very capable hands. But thank you very much and welcome everybody.
That's great. Thank you, Jenny. Just a few housekeeping points at the beginning before we get into the session properly. If you have questions throughout, and you may well do because it's a fairly complex subject area, feel free to either keep them till the end and you can raise them verbally because we've got a relatively smallish number of attendees, or you can put them in the chat box. So for those of you who are on Teams properly, fully, not on the telephone, you can put your questions in the chat box, and I promise I'll pick them up. With Heather's help, I should pick up all the questions at the end if we haven't answered them as I go through. So that was the only point on admin. We don't have to do that thing anymore where we tell you where the exits are, because you hopefully will know where your exits are, given that most of you are at home or in the office, which is good. So just a very brief introduction then to me and Hempsons. I am the National Head of Employment at Hempsons, and Hempsons is a firm that deals primarily with healthcare organisations. We act for over 200 NHS bodies, and the reason I say that is because it gives us a bit of an insight into the sorts of issues that you might face as NHS organisations across the country. So that's all I want to say about the organisation. In terms of the session itself, the session really is a taster, I suppose, of the sort of issues around industrial action and how you might handle that as an organisation. The purpose is just to give you a sense of the issues. It is a fairly complex area, and it's governed by a whole set of regulations and statutory provisions, which are, it's safe to say, at times quite complicated to understand. And difficult sometimes to implement in practice. But what I'm going to do is give you a sense of sorts of issues around industrial action, and that will at least give you a foundation to deal with issues as and when they arise. So, a little bit of background, which I think might be useful. It's certainly true that outside of the public sector and certainly outside of the NHS, until relatively recently, industrial action has been a thing of the past, and I remember in the early parts of 2012-13, when there were issues around pension and so on, that it came as a little bit of a shock, I think, to some NHS organisations that industrial action was back, national industrial action at least, was back on the cards. So so that's a positive thing in many respects, because it means that the NHS generally in recent years has not had to deal too much with difficult industrial conflict. And the sorts of things that can lead to those kind of conflicts and industrial action can be local. And so certainly regionally and nationally, there have been some threatened and in some cases actual industrial action around the setting up of wholly owned subsidiaries, for example, by NHS organisations. So it can be a local reason, or it can be a national. So going back to the early part of this decade, issues around pension. At the moment, there is, of course, some discussion around whether or not there might be industrial action in relation to the 3% national pay award. Some unions are setting up what they describe as consultative ballots. In other words, dipping your toe in the water to see whether there's an appetite for industrial action. These are not formal ballots, but they're just an assessment of where members might be in terms of taking industrial action. So that is one of the reasons why we thought this session would be a timely session, because it is at least possible that the NHS will see more industrial action in the years to come. So that was just by way of background. I wanted to talk now at the meat of the session about the law in relation to industrial action and some of the issues that arise. The starting point, which I think is important, is that the general principle is that striking and taking most industrial action is a breach of contract. You are employed to provide your services, you're employed to do it in that way, and therefore withdrawing your services as an employee is in theory at least a breach of contract. And most other types of industrial action, not just striking, will amount to a breach of contract. So that's the starting point. But then, of course, employees and unions have protection. And so there is an immunity from liability if the industrial action is lawful. And one of the themes that you'll see in the case law is around this point. Has the union done what it needs to do to make sure that the action taken is lawful action? In other words, is it therefore protected from liability? Because if the action is lawful and the procedural requirements have been done and there is a trade dispute, which I'll talk about in a second, all of those things, if it is lawful, then the unions themselves are protected. Because if that wasn't the case, potentially there's all sorts of action that employers could take against unions, because the unions are, of course, calling for members to come out and breach their employment contract by not providing their services. So that's the starting point. And the key thing there is that there are certain elements that are required for strike action or industrial action in the broadest sense to be given that protection from liability. So I'm going to look at those in turn. And the first, well, I'm talk about industrial action. Let's go back to the, beg pardon, let's go back to this point about trade disputes. So trade disputes generally are not much of an issue anymore. It used to be the case that there was a lot of dispute about what a trade dispute amounted to. Certainly at the moment, the sort of issues that are potentially the subject of industrial action are clearly trade disputes. And trade disputes really amounts to a number of things, but in this particular case, it's pay. The thing to bear in mind, and this is something that goes back to the pension dispute, the thing to bear in mind is that generally speaking, if the unions are calling for what one might describe as political action, it's not going to be covered by the protection. If it relates to the terms and conditions of their members, which it will do in nearly every case, then the chances are it's going to be a trade dispute. So that's not much of a source of contention for the most part. And I'll talk about ballots and notification requirements. So I suppose a good starting point is, what is industrial action? We talk about industrial action. There are varieties of industrial action, but what is the definition? Well, it might be a bit surprising to know there isn't a statutory definition at all. The courts have taken the view, and in fact they've expressed it quite clearly, that you know it when you see it, that industrial action can take different forms, but actually for the most part it's obvious that it is industrial action. And one of the best definitions is a concerted action taken to put pressure on employers. That's not a statutory definition, that's just a general understanding of the sorts of things that might amount to that. Why does it matter? Well, it matters to an extent because if action is different from a strike, so I mean, strike is straightforward, you're not working, it's a stoppage of work by employees acting in concert. So everybody knows a strike when they see one. What may not be so obvious is action short of a strike. So things like the overtime ban, working to rule, and so on. And certainly historically, the sort of action short of a strike can cause more operational difficulties. If you're an employer and you know that certain categories of employees are going to be withdrawing their labour within a certain time period, it's not easy, of course. And we saw that in some of the national industrial action. It's not easy, but you can plan ahead. The difficulty is where employees are acting in a way that's short of a strike. So, working to rule, that's very difficult sometimes to manage. If people are interpreting their contract in a very literal sense and only doing the items that are required of them, if they refuse to take on overtime, for example, all those sorts of things can cause more operational difficulties than a strike, in my experience. But that's industrial action, very broad category of things. Sometimes it can be important to ascertain whether or not people are in fact taking part in industrial action. And this is the courts have said this is a question of fact. The sorts of problems you come across are issues around people taking sick leave, booking annual leave, and so on. and whether or not they are associating themselves with the industrial action. So employees may not want to say, I'm going out on strike. They may not obviously do that. They may not man the picket lines. But in reality, it may be that they're trying to come out in solidarity with their other colleagues and take sick leave and annual leave. The factual question is whether or not in any way you can say the employees have associated themselves with the action. And that's very difficult. If somebody suddenly calls in sick on a day of action, it's very difficult for an employer to say, well, we think in fact you're striking, rather than having a day off sick. So it's very difficult in practice. But if people start booking annual leave, you can ask different questions and see whether or not the employee may be said to be associated with the action. Because of course it all goes down to pay and how you treat the employee for that period, which can be relevant. So that's what the ASLEF case says. The ASLEF case, relatively old case now, but what it says is you have to be able to say the employee has somehow associated themselves with that action. So it's not what they intend, it's what they do. Has an employee, for example, refused to cross a picket line, that through the case law would indicate they're taking part in the action. One of the slightly odd things, and this is something which came up in the pension dispute going back to 2012, 2013, one of the odd things is the protection for non-union employees. And I say it's a little bit odd because it sounds a bit counterintuitive. But if you think about the protection that's offered to union members, I'm going to talk a little bit more about that in a second. But if you think about the protection, you've got a union, calls out its members, you're a member of that union, you come out in support of the industrial action, you are clearly protected. So that's straightforward. If you are not a member of a union at all, and you come out in support, so you come out as part of that industrial action, you are protected. That might seem odd. So you're not a member of a union at all, but you decide to take industrial action alongside your union colleagues, you are still offered the same level of protection. This is where it gets slightly odd, and there is a justification for this, but who are the people who are not protected is employees who are members of other unions. And so if you're a member of another union and your union has not gone out to ballot and has not gone through a lawful process, you do not get the protection that's given to those other people. So it might seem a little bit odd because you can not be a member of a union and still be protected. But I think the justification, the logic is, if you are a member of a union, that union could have gone out to ballot. They could have decided to take lawful action. They haven't done that, and therefore you can't get the protection. So non-union employees protected if they're part of the relevant grouping. And so obviously those who have been part of members of a union that's called its members out on a lawful strike or your lawful industrial action. The procedural requirements around ballots and so on are fairly complicated. I've tried to distill them into the most important elements, but they can be quite complicated. And I have to say that historically, some of the challenges that we've seen in the courts have been precisely on this basis, that somehow the relevant union has not complied with its procedural requirements. So it can be a little bit of an issue, it can be complex, but I've tried to distill it down into the most important aspects. So the first part is notice of a ballot. So no later than 7 days before a ballot starts, the union needs to inform relevant employers that this is what they're intending to do, that they're intending to issue a notice of ballot. And they should give the employer, as much as they're able to, a list of the categories of employees and the sorts of numbers that will be affected if they decide to take industrial action. So the people that will be balloted in effect. And within that, you can have reference to the checkoff process. So you can refer to that in terms of the sort of numbers and categories of employees. The idea is that the employer should have a reasonable opportunity to plan for the industrial action, to understand the repercussions so that they can take appropriate action. That's the logic of it. Now, very often those figures and those categories of employees and the description can be inaccurate. And that's often been where employers have challenged and tried to get an injunction, for example, to either stop the ballot or stop industrial action on the back of the ballot, because they will argue that unions have not taken reasonable care in producing those kind of figures. But the view of the court is that they are fairly relaxed about relatively minor errors. And so, for example, I've had cases where a relatively small number of employees who were entitled to vote, were not sent ballot papers. And in those sorts of cases, the courts are reasonably relaxed about that, as long as it doesn't appear to have been a deliberate attempt by the union to kind of somehow change the outcome of the ballot. So that's notice of ballot. The employer should be aware. The ballot paper should be given to the employer no later than 3 days before the ballot itself. And that ballot paper should include a brief summary of the dispute, what the proposed action is, and the time periods for that action. Now, again, this is another area where employers sometimes want to challenge, because it may well be that the ballot paper includes an inaccurate summary of the dispute, for example, or is unclear around the proposed action and time periods. So again, it may be at that point that the employer decides to take an injunction to try and stop the ballot from going out to members. For the most part, employers, I think, will probably not strike at this stage, or no, that's the wrong word, not take action at this stage. They'll probably wait and see what happens with the ballot itself, but it certainly is an option potentially if there is an infringement of the provisions. And then, of course, the ballot takes place, and the results of the ballot needs to be announced and within a reasonable period of time given to the relevant employers. There are some requirements around the ballot itself, which were introduced relatively recently. There has to be a 50% turnout in terms of the ballot itself to make it a valid ballot. And then in addition to that, for important public services, there needs to be additional 40% support for all entitled to vote. Now, that is the sort of thing that you need to put a wet towel on your head, try and understand. Let me explain it in terms of numbers so that you get a better sense of that. Let's say you've got a very small workforce that are entitled to vote. Let's say it's 1,000 people. You need to have 500 people who have turned out to vote, to register in some way. And then of those 1,000 people in total, you need at least, well, you need a majority in order for action to happen, but you need at least 400 people who have voted to support the action. So there's an additional barrier, because for people that are not part of an important public service, it's a simple 50%. So 50% of the people that are able to vote say yes, then that's enough. But there's an additional requirement for those people that are in important public services. Now, I'm not going to go into what that amounts to in any great detail. There are some regulations which govern this. There's a whole list of services that would include A&E, high dependency units, psychiatric services in some cases, emergency ambulances, and so on. It's a whole long list of areas where employees might be considered to be part of an important public service. Occasionally we get into disputes around that, particularly if you've got somebody who's got, say, split responsibilities. But for the most part, it's pretty obvious whether somebody would fit within those categories. So that's an additional provision that obviously directly affects those in the NHS. So once the ballot's happened, the union then needs to give notice of industrial action. And industrial action could be, in the words of the guidance, either continuous or discontinuous. Continuous just means on all relevant days. So that's, we're striking for 2 weeks and we'll be out on strike for the whole period. Discontinuous means that there's a period and we're going to take action on some of the relevant dates. So it's discontinuous in that sense. It's not from beginning to end. And the dates have to be given, and at least 14 days notice of each, the start of any action needs to be given to the employer. Again, the idea is that you shouldn't be taken too much by surprise when industrial action kicks in. There's also an issue around how long the ballot can be effective for, and the answer is 6 months from the date of the ballot. That's any time during that 6-month period action can be taken, and it can be given an extension of up to a further 3 months, so 9 months in total, but with agreement with the employer. Now, you might think, why would you agree to a further period? And the answer could well be that if you're trying to resolve a dispute and it's coming up to a very long period of time and there hasn't been industrial action, you may well agree in the hope that somehow industrial action can be avoided, but you may agree to it on the basis that you might be close to a deal. So there is a shelf life, if you think about it that way, to any particularly successful ballot. Where might you challenge? And so this is one of the issues that we've looked at over the years, where organisations, reluctant as they might be to challenge, have considered challenging. And I mean, I would say as NHS organisations, this has been a very difficult thing over the years because NHS organisations, for the most part, work pretty successfully in partnership with trade union colleagues, and there has been a real reluctance to say, shall we challenge the process? But certainly in recent years, I've seen a slight increase in the potential for challenge, if I can put it that way. I'm not aware of any significant challenge to some of the national strikes or some of the local strikes that we've had, not really in terms of process, but it is always something that needs to be considered, I think, from a responsible employer's point of view. And these are just some of the things that it's almost like a little checklist of things that you as an employer might think about in terms of whether or not the action is lawful. The first issue is trade dispute, which I mentioned very briefly before. And if you go back to the definition of trade dispute, it is a dispute, obviously, as you might expect, between employer and workers. And it's got to be connected with a number of things, including terms and conditions of employment, dismissal of workers, allocation of work, that kind of thing. So it's a fairly broad definition. And the question really is whether or not it's a trade dispute or whether, as I say, it's a political dispute, but it is pretty wide. And even if there is a political element to it, like there was arguably in some of the recent industrial disputes, even if there's a political element to it, the reality is if it does affect terms and conditions, you're going to be able to say, the unions are going to be able to say it's a trade dispute. So probably not a great opportunity to challenge. A better opportunity potentially is in terms of the ballot requirements and things like the notice for action to be given, information about action to be given. So, things like, has the union balloted the right groups, for example? Has the wording of the ballot been in accordance with the requirements? Those kind of sort of pedantic things that lawyers kind of pore over to see whether we can find any defect in the ballot process. But as I say, even if there is a defect, it's got to be serious enough for the courts to say there is a ground for injunction. And an injunction, as I'm sure some of you will know, at least if not most of you, an injunction is where the employer goes to the High Court and says, look, the trade union has not complied with their requirements, and therefore this action would be unlawful, so we're going to stop it in its tracks. And if that's right, if the High Court agrees, then the union cannot proceed with their, well, it depends on what stage it is, but they cannot proceed ultimately with the industrial action. They may be stopped in their tracks even in terms of the ballot itself. So it is an option, but I would say it's an option that NHS organisations in particular would take very seriously and would not do without just cause, because it does seem to me to be quite a confrontational action to take in the face of industrial unrest. So just be aware, there are some areas where you might be able to challenge. One thing which is not peculiar to the NHS, but is a particularly important consideration, and it was something that we discussed with a lot of our clients in some of the last rounds of national action, was this provision, which is called Section 240 of TOLCRA, as employment lawyers call it. And this is a criminal offence. So this is a criminal offence where you willfully and maliciously break a contract of services, knowing or having reasonable cause to believe that the probable consequences of doing so will be to endanger human life or cause serious bodily injury, or to expose valuable property to destruction or serious injury. So in effect, what this provision does is it says if you are a union and if you call out your employees, your members, and you're doing it in a way that's both willful and malicious, and where you've got reason to believe that it's probably going to lead to endangering human life and so on, if you're in that position, then it's a criminal action. And so, it's something to be mindful of, particularly if you're dealing with members of a union who may be taking industrial action in relation to, seriously ill patients, A&E, and so on. It may be a provision that you want to at least be mindful of and draw attention to the trade unions. Trade unions are mindful of this. I think all the national unions are very, very mindful of it, Section 240. But it does give you a potential to say to the unions, look, actually, we need to be thinking very carefully and very seriously about the repercussions of this industrial action, because this is at the back of this, there is a potential criminal sanction if you fall foul of it. Now, one thing I should say from all of this is that as far as I'm aware, and I haven't checked I haven't checked in the last couple of days, but as far as I'm aware, there's not been any successful action ever under Section 240 in this way. So it is something that the courts would have to dust down. It's certainly been threatened on a number of occasions. I'm not aware of any successful challenge, so it's a very difficult provision to apply. And if you think about it, you know, if you're a trade union, are you really in a position where you think the probable consequences of what you're doing is to endanger human life? Maybe, but you know, it's a difficult burden to shift, I think. One of the practical repercussions, and this is something which if you've been involved in industrial action, you'll know full well, one of the practical repercussions of this, and sort of common sense anyway, is that as far as possible, you want to try and seek exemptions from action from the unions. You want to try and agree that certain categories of staff, whilst they may be entitled to strike because of the repercussions, they will maintain their services throughout that period. And it often is the case that you can do just that you can seek limited exemptions from action for some members of the union. But it is something just to be mindful of. There is a provision which talks about the use of agency workers. I would start by saying that you should bear in mind that for the most part, substituting people for those that are on strike is not a major problem. So if you use existing staff, for example, to cover for people who are on strike, no issue with that. Where there is a prohibition, however, is where it's in relation to an employment business. So what you can't do if somebody's on strike is simply get somebody from an agency to cover those duties, or indeed to cover the duties of staff that you've already moved around to cover for striking staff or those taking industrial action. So that's a prohibition and it's a criminal offence. The agency would be liable in these cases. Potentially, as an NHS organisation, as an employer, you might be guilty of aiding and abetting. So it's a serious issue. And you need to look at alternatives really to using agency staff. So use existing staff. You can employ people directly. There's no prohibition on that. And so you could have temporary workers who come in to help. You can have people who are volunteering. You could temporarily, at least, outsource the service. There's nothing to prevent you from doing that. So you could have a sort of fairly quick cheapy process, for example, where you outsource that service and then take it back at the end of the industrial action. It may be impractical to do that, but it's certainly theoretically possible. So keep in mind the only prohibition is on agency staff and the supply of staff through agencies. Now, the Conservative manifesto in 2015 said that it was going to remove this exemption. And it was going to allow, therefore, the use of agency staff. It consulted on this and has reached the conclusion that it's not something they're going to implement, certainly not for the time being. So this prohibition on agency staff in the context of industrial action is still there. You still can't use them. I'm just going to say something briefly about picketing, because the rules on picketing and the code on picketing, the code of practice, is fairly convoluted and at times fairly complex. I don't say huge amounts on picketing, but the description that's used in the new provisions is peaceful picketing. So peaceful picketing is allowed. It's not exempt from criminal action. So if somebody is picketing and they decide to come onto premises and trespass or damage property, or they block entrances and they're violent, all that stuff, there's no exemption for that. And so it's in the normal rules of things. If their behaviour is inappropriate, then it could be subject to criminal action. The code of practice has been heavily revised and is also now taken into account seriously by the courts in such cases. And again, I've summarised it very briefly, but the suggestion is that you shouldn't have more than 6 people at one place who are picketing, and there should be somebody from the union who is known as the picket supervisor. The logic is you should, as an employer, be able to go to the supervisor to say, look, concerned about this, or I'm concerned about that, or can you, behave in a slightly different manner. And the idea is you've then got one accountable person in relation to the picketing that you can talk to. I think this is one of the areas that can cause employers some difficulties about what's lawful and what's not lawful. I've had queries over the years, for example, about whether you have to allow pickets onto your premises, and the answer is you don't. Unless they've got good and lawful cause for being there. And so really a picket line should be on the outside of your premises rather than on, because otherwise potentially it's open to some sort of trespass case or moving them on. And again, in terms of the numbers, it can be incredibly difficult, even if the unions are intending to have only 6 people on a picket line, it can be incredibly difficult to maintain that, because of course people are coming and going and they often will stand there and have a conversation. So in practice, it can be tricky. I think in recent years, the experience I've had is that for the most part, unions are pretty sensible and work in conjunction with employers to get a sense of what's lawful and what's not lawful and what's appropriate. But you can have those issues. So just be aware, have a look at the code of practice if you've got any specific concerns. And if you've got any questions, I'm more than happy to pick them up. But that is an area that can be difficult in practice. Pay. Let's talk about pay briefly. Some obvious points, I suppose, but if somebody is striking, they have no right to be paid. And that goes back to one of the points I was making earlier on about whether somebody's actually striking or whether they're taking sick pay or whether they're taking annual leave. Can be relevant because you're not entitled to be paid during a period of strike. It can be tricky if somebody says, if you've got, for example, a shift that crosses over a day of action, which is something we've had in the past. The question is, as an employer, are you prepared to accept what we describe as partial performance? In other words, are you prepared for that employee to strike and then come in for, say, half of their shift or a quarter of their shift or whatever? And what the law says is you don't have to accept that. So if somebody says, I work, I don't know what shift, but let's say I work an overnight shift, industrial action comes to an end at midnight. I would like to come in from midnight onwards and work through till 5 or 6 or whatever time it is. You as an employer don't have to allow that. You can say, look, tough. Your shift happens to fall across this period. If you're taking industrial action for the first part, we're not going to pay you for the second. We don't want you in. However, of course, if you do accept partial performance, you need to pay for it. So if they do come in for part of their shift, then generally speaking, and the rules are fairly complex on it, but generally speaking, you make a prorated payment rather for the remainder of that shift. So it's up to you whether you accept it. In the last set of national industrial action, because of the difficulties it might cause, I think most employers accepted partial performance because it was better than nothing. The idea was getting somebody in for a quarter of their shift is better than not having them at all. But in principle, you don't have to accept partial performance. Just coming up towards the end of the session, then just a few things that are really important, but I didn't want to dwell on them too much. These are areas that can give rise to particular claims, and that's in relation to detriment and dismissal. Dismissal in many respects is more straightforward, and so if somebody is dismissed because they've taken action in official protected industrial action, it's automatically unfair. And as a reminder for some people, all that automatically unfair means is that whatever process you followed, however you may think it's fair, it's not. And so the individual will succeed in their claim for automatically unfair dismissal. So dismissal in some respects is straightforward conceptually. The question always is whether or not it's because of them taking part in industrial action. You may have cases where somebody's going to be dismissed in any event. They then strike and they try and argue that it's because of the industrial action where it may be completely unrelated. So the tribunal has to see a causative link between the industrial action and the dismissal. Now, detriment, the issue of detriment was certainly a lot less clear until this year, 2021. And there's a case called Mercer. And the reason it was less clear is that there was a little bit of a loophole in the legislation. And what that said was if you subjected somebody to a detriment because they had taken action, because they had taken industrial action, if you subjected them to a detriment, so for example, if you suspended them, if you withdrew some of their pay, if you demoted them, it wasn't a breach of the legislation. And that's what the loophole said before. But there's a case called Mercer, which came out this year. It's an employment appeal tribunal case, and I don't think it's being appealed. The Mercer case looked at this issue again and said and reached the conclusion that activities of an independent trade union, which is the relevant wording, should include preparing for and taking part in industrial action. So what does that mean? Well, it means if you subject somebody to a detriment, not just because they've taken part in the sort of normal day-to-day activities of a union, so attending meetings, taking part in advocacy, all that kind of stuff. If they take part in industrial action, they appear after the Mercer case to also be protected from that as well. So, I mean, I'd be surprised if most NHS organisations thought to themselves, look, somebody's taking industrial action, we're now going to subject them to a detriment, and you rub your hands with glee like some sort of evil landowner. I don't think that's very likely. I suspect that wouldn't be the case deliberately or intentionally. But now you know that those people in that situation certainly have the protection, and they could bring claims on that basis. So the way to think of it is, if you're taking any action against employees on the as a result of lawful industrial action, you could face a claim on that basis. The final point really for me is not a legal point, but it's a practical point, having been through quite a few of these disputes and advised a lot of employers on these disputes. And it's a practical point about communications, because I think for all the complexity of the legislation and for all the difficulties and for all the complicated practical issues, one of the key things for me is communication. I think that, you know, if you're managing staff well and you're engaging with the issues that are of concern to staff, to a large extent, you can remove some of these practical difficulties. And I think, again, my advice is, when it comes to communication, trade unions are very good at getting their side of the story out. They're very good at communicating. Sometimes that communication can be inaccurate. Sometimes that communication can be slightly inflammatory. It's important as an employer to make sure that you counter some of those arguments and that you counter some of the more potentially more misleading comments, which I've seen in a few cases, and that you properly engage with staff, because you shouldn't forget that at the end of this, at the end of the day, if it comes to industrial action, people still have a choice about whether they take it. So I think that's important. And then if it's a local dispute in particular, focus on those who are affected and understand those concerns. So going right the way back to the beginning, I think the trusts who managed the wholly owned subsidiary move the best were trusts who properly and fully engaged with staff, not just the unions, but engaged properly and fully with staff on the concerns and tried to allay them. Doesn't always prevent industrial action, but it certainly makes it a little bit easier to manage if that's what you've done as an employer. So that's my final slide. We have plenty of time, quite deliberate, in fact, for questions. If anybody's got any questions on what I've talked about, or if there's any issues around industrial action that I haven't covered, then by all means put them in the chat. I'm going to have a look now. So the way we're going to run it is the way we normally do it, which is I'll look at the chat questions first and I'll attempt to answer those. And then if people want to unmute themselves and ask a question, we'll have time for that if it's easier to explain yourself that way. So a question here about if you had agency staff book due to high vacancies, would this also fall foul of this? No, I mean, there's very limited cases on it, but there has to be, if you've already booked agency staff before you're aware of the industrial action and your intention is not to cover people because of the industrial action, you should be fine. The difficulty is, I think, and I have had this case once before with a particular strike, the difficulty is where it isn't immediately clear the basis upon which you book the agency staff. So, but as long as it's clear, as long as it's got nothing to do with the industrial action, you shouldn't have a problem. It's whether there is a connection, and that's one of the issues. As long as we're already pre-booked further in, yeah, that's correct, Louise. That's right. I mean, absolutely spot on. So if you've already booked agency staff, somebody's answered a question for me, which is great. So if anybody else would like to answer that question, it's fantastic. Any other complicated questions, Louise, if you want to pick those up as well, that'd be great. That'll help me a great deal. But you're absolutely spot on. It's absolutely right. If it's booked for another reason, you won't have an issue. Re-sickness on days of industrial action. Can we ask for a fit note for this occasion? Well, it depends on your contracts, is the honest answer. You may have a provision that says that we can require you to provide a sick note for any day of sickness, but I'd be surprised if you have that. Most employers wouldn't necessarily have that. They'll have something slightly more vague. And of course, for the purposes of SSP, you don't need to provide a doctor's note for the first period of sickness. So it all depends on whether you've got the right to do that. Go back to your contracts and see whether you've got the right to do that. I think if you have more than just a vague suspicion, you might be in a stronger position, because it could well be a reasonable management instruction at that point. So if somebody, so for example, let's say you've got somebody who says they're off sick, and then immediately here they've been telling all their friends that they're not off sick and that they, you know, in fact, they're just taking part in industrial action. That, it seems to me, could well give rise to you asking for medical evidence on that particular occasion because of the surrounding circumstances. And of course, that might amount to a disciplinary in any event, because you may have an employee who's been lying to you. But it is difficult. It is difficult, I think, in these situations, unless you've got some pretty good proof. Any other questions in the chat? I don't see any questions in chat. So should we, if anyone wants to unmute themselves. Oh, we've got one. Sorry, it takes me a slight lag to get the questions in my other. I've got two machines. I'm not boasting. I'm just trying to work out where we go. Here we go. Louise, thank you. A couple of points from prior experience. Don't forget the impact on call cover of those taking it. Yes, absolutely. And the impact of other organizations. Yes, absolutely. Absolutely right. You've got to see it in context. It's really important. I think the level of planning around industrial action that I've seen in practice is enormous. And very often I've had clients who've said to me, look, we've just realized the repercussions of this. We thought we'd thought of everything. We really haven't. Something has just come up and we're going to have to deal with it quickly. So it can be very difficult for a large organization. It can affect ambulances. You're quite right. It can affect other organizations in many respects, of course, particularly when it comes to a national strike. When it comes to a national strike, then you've got all sorts of issues that are not obvious immediately when you sit down to plan for it. And I can also say in experience that the exec corridor of trusts that are facing industrial action often are incredibly busy and incredibly concerned, genuinely concerned about the repercussions. If you've got very good trade union colleagues, you can very often reach sensible agreements and understandings with them. Not always the case. Sometimes you're not able to reach what you consider to be a safe set of understandings, but for the most part, the earlier you can plan for it, the better. There's no other points I don't think in the chat. So if anybody would like to unmute themselves and ask a question, if you've got one, you're welcome to do that.
Andrew, do you mind if I come in on a couple of the things that you've just answered, if that's okay? Just potentially while people are thinking of other tricky questions for Louise to answer, I think. Yeah. So the first thing is it's a lot more difficult in my experience to deal with that loss of discretionary effort. So not a full-blown strike, but the kind of work to rule. I think that's really, really hard to plan for. And I didn't know whether you'd any further comments on that. And the other thing I just wanted to explore a bit further is the sick note question. So presumably, if kind of processed and concluded properly and a clear delineation between the conduct matter, which might be lying about the fact that you're sick or not, and the industrial action would mean that the fact that the dismissal might take place if that process concluded, you have to be clear, it has nothing to do with the industrial action. Yes. I think is what you're saying. So that wouldn't impinge on that process.
Correct. And I think a tribunal would have a great deal of sympathy for an employer who said, look, actually, this is a massive trust issue because somebody has just clearly lied about their condition. I think in practice, you would have to be incredibly cautious about going down that path. Because, I have had cases, not recently, but I've had cases, for example, where an employee who did just that, an employee who said, I'm actually off sick, and they phoned in sick on that morning, when they weren't sick, but what their response was I was concerned about threats from other colleagues. I was concerned that if I didn't take action in some form and therefore associate myself with the action, I'd be in difficulties. So you've got to explore it a little bit more. I think in practice it's probably it's probably almost for the too difficult pile in most cases. I think an employer in this situation probably has too many other things to deal with. As long as it's a relatively, minor issue in terms of numbers, I think if you get one or two people who phone in sick, for the most part, employers are pretty pragmatic, and they may have their suspicions, but how are you really going to make any headway with it unless you've got really clear evidence? So if somebody says, I was too sick, I couldn't get out of bed, and then you see them in Morrison's, I mean, you might have good reason. But then I think back to your first point, which is it connected with the industrial action? Well, it's connected, but it's not the reason for the dismissal, because you've got an employee who's clearly lying. But it's like, just take it broader. How many cases of malingerers do you actually take through to a disciplinary hearing and sack? Not many, because it is too difficult to get the evidence together that you feel comfortable with to say somebody's just lying to us rather than actually feeling not very well.
And then the added complication here is the industrial action overlay, isn't it?
Which inevitably somebody's going to throw into the mix and say that that it was effectively because somehow the employer thought I was associated with the action even though I wasn't. So I would take a deep breath before you decided to go down that route. I'm not saying don't do it, but I think the practical difficulties and the potential liability issues are not insignificant. Put it that way.
That's really useful caution. And then the other question I had, Andrew, and I don't think we've touched on this, is about where there might be pressure being put on. I think you mentioned it, pressure being put on an individual to strike, and I wondered whether you've any experience in that sort of arena and what some advice might be in that.
I mean, it is incredibly difficult. I think there are some cases on the what I would describe as the boundary between encouraging people to take industrial action, which is entirely legitimate and reasonable, and overstepping that boundary. There aren't many cases on it, but there are some cases on it. Because, of course, if it's another employee who's doing it, then in theory, again, you're in the realms of misconduct. If somebody is applying pressure to a colleague to take industrial action in a way that's inappropriate, you're in the area of misconduct. But it's a similar point, if you are a representative of a trade union and you are quite assertive in expressing your view and encouraging, in inverted commas, colleagues to do that, where do you draw the line, between encouraging and suggesting that people are not really being cooperative and all the rest of it? Where do you draw the line? If it's inappropriate, then again you need to take action. But I think it can be incredibly difficult. If an employee feels threatened and they've got good reason to feel threatened, then you're in a totally different ballpark and you're in misconduct territory, notwithstanding that somebody is a member of a trade union or a trade union rep. That shouldn't make any massive difference, but of course at the back of your mind it will, because they will say they're taking part in their trade union activities and all they're doing is encouraging. And it may look like the sort of encouragement you get from the mafia, but nevertheless it's still encouraging, and so you've got to take a view. So look, it's a difficult question. I have come across it in practice quite a few times. The way that I think you would naturally deal with that is if you have got a particularly aggressive trade union representative, the way to pick it up is on a regional level for the most part, and say, look, we are concerned because this individual is going around and causing more difficulties than they're not. And again, my experience over the years has been that most regional reps are pretty sensible and will sometimes, pull back the dogs of war and tell their members to calm down a little bit. So yeah, that's not law, that's kind of practical. What would I do? I would always go to the regional rep at that point and say, look, we've got a problem. But yeah, and of course there's also issues around potentially going to the Freedom to Speak Up Guardian and protecting them in terms of misconduct cases. So not easy. I've not seen much of that, I have to say, Jenny, in practice. Not seen a lot. Whether that's just because those issues don't come to our attention, I don't know, but I've not seen a huge amount of what I describe as intimidation.
And I think it's really sensible advice, isn't it? And generally, the union reps certainly that we deal with are really pragmatic, sensible, helpful, which is great. It's this whole topic purports to be very straightforward, but it's the grey areas, isn't it? Completely. It's the ambiguity around these margins, which is tricky, I think.
Completely. The principles are not complicated. The principles in terms of having, there isn't actually a right to strike. I think of it more in terms of a sort of conditional right to strike, but those kind of things, and the right of the employer to understand what's going on, all of those principles are straightforward. But you're absolutely right, it's not the principles that cause us problems, it's the what to do at 4 p.m. on a Friday afternoon when we've got all these issues arising in a department. That's a problem. And the operational, you can't underestimate the operational challenge sometimes for NHS organisations when industrial action is prolonged. Do we have any other questions or observations or anything which wasn't clear from the session? No, you've been a very, very well-behaved audience. If you have got any questions, you're welcome to put them in the chat box. You're also welcome, incidentally, if you've got any questions, to send them to me. You've got my contact details there. You're very welcome to send me an email or some form of communication. All good. If you want to follow me on, the slides will be shared. We'll send them around. That's no problem. If you want to follow me on Twitter, I'm desperate for new followers. Slightly pathetic attempt to get people to follow what isn't a very exciting account. So please do that. But if you've got any issues at all, you are very welcome to get in touch, and I can help you as much as I can.
And just to say a very big thank you to you, Andrew. It's been a really useful session. There's lots of good comments in the chat, and thank you to everybody for joining. And I do hope we're not in the position of managing some of this through the winter, but thanks everyone, and take care. See you soon. Thank you, Andrew.
Thank you. Thanks everybody.